Good evening, everyone, and welcome to today's webinar hosted by Hockey Québec, Risk Management and Legal Consideration in COVID-19 Situation, Answers to Questions and Ambiguity. My name is Marie-Josée Desaulniers, Communication, Marketing, and Member Engagement Director. First, I would like to introduce my colleague online with us tonight, Mr. Yvan Dallaire, Rules and Regulation Director, and Mr. Paul Ménard, our Director Manager. And of course, our board members, including our President, Mr. Yves Sigouin, who would like to say a few words.
Thank you. Good evening, ladies and gentlemen. This presentation will be given by Steve Lacoste from BFL and Peter Moraitis. Peter's a lawyer and Peter's going to be talking to us about risk management. We're very lucky to have both those guys with us tonight doing the presentation. I want to thank each and every one of you to be present, and I won't take that much time, so the presentation could start right now. Thank you.
Thank you, Mr. Sigouin. Before we go further, I want to review the functionality of this webinar. Right now, I have everyone on mute to avoid background noises. You can send us your question in the Q&A box just below during the presentation. There are two options. Your question may be answered to you right away, or we will prepare a Q&A and send it back to you in a few days with the link of the recording of this presentation. Before we start, my colleague, Rules and Regulation Director Yvan Dallaire, will present you the objective of this webinar.
Bonsoir tout le monde, good evening. First of all, I would like to thank everyone for joining us tonight. Our two presentations, as Marie-Joëlle said, entitled Risk Management and Legal Consideration in a COVID-19 Situation. We'll hopefully answer a lot of your questions tonight. Our two guest speakers will offer you various practical tips in different topics. Let's just think about governance, insurance issues, risk management, waivers, and assumption of risk. Without any other delays, let's go back to Marie-Joëlle for our first speaker introduction.
Thank you, Yvan. Now, I would like to introduce our first speaker, Mr. Steve Lacoste. Mr. Lacoste joined BFL Canada in 1998. He leads BFL's Canada sports and leisure practice and handles a wide variety of sports associations, both provincially and nationally. He started his career in the insurance industry in 1986, and he is experienced both as a client executive and as a claims adjuster in the field of sports. He was for many years a member of the Hockey Canada's Risk Management Committee and was overseeing numerous risk and safety issues across Canada. Mr. Lacoste holds his broker's license in all provinces. He was a leader member of the VIP program for the 2017 EHF World Championship. So,
thank you, Marie-Joëlle. Thank you to everybody for joining us this evening for tonight's presentation. We're going to do a brief overview of Hockey Canada, Hockey Quebec's insurance program, and we will obviously touch on a few risk management issues related to COVID, obviously, which is the topic of 2020 right now. So we will start by just going over Hockey Canada and Hockey Quebec's insurance program. Let me get my screen working here. So first off, as volunteers within Hockey Quebec, you really want to know exactly what you're covered for, who is a member of Hockey Quebec, who is a member, therefore an insured under the insurance policy. So we'll go over these briefly. So on the screen, you can see exactly who is a member in good standing of Hockey Quebec's insurance program. So you have your regions, your teams, your leagues, your players, your coaches, your manager, officials and referees, directors and officers, staff and volunteers. So if everybody who is part of your organization falls into this box, that means that they are insured, that they are covered under Hockey Canada, Hockey Quebec's insurance program. Members who are not covered, it is important to note those that are not covered as well as those who are covered. So when we say parents, private entrepreneurs, private coaches, and bus companies, those are the three major components as far as members who are not covered within the insurance program. Important to note, because we've had this, I was a coach for 7-8 years here in the West Island for Lakeshore, so I've been in your shoes as well. So when we talk about parents, so a parent is simply there to drive their children to practices. It goes back to the previous slide where they would be covered under the policy. And the reason that we put parents at the forefront of members who are not covered, I'll give you the example at Christmas time or at the end of the year. Often, you know, we'll have requests come into our office where you want to have a parent player little fun game taking place on the ice. Parents are not covered when they are on the ice. So that is an absolute no as far as events taking place. Just so please take a quick note of that. Private coaches, often again, you'll have private coaches that want to go on the ice to give power skating lessons, you know, things along those lines. You have to realize that if that coach is not part of the HCR, the Hockey Canada registry, they are not covered under the insurance policy. And we're not saying that you can't do it. They are allowed to go onto the ice, but you need to absolutely make sure that that specific private coach has their own insurance in place in the event that something was to happen when they were on the ice. Bus companies, the reason we put bus companies up, everybody is aware what happened in Humboldt with the Humboldt Broncos. You need to realize that if you do rent a bus for travel with your team, you need to make sure that that bus company has their own insurance in place prior to leaving to go to your event. Now, when are you covered? So obviously you're covered for sanctioned activities under strict supervision. When we talk about supervision, we mean that the coaches are present, the manager is present. So during practices, camps, clinics, games, tournaments, off-ice training, meetings, fundraisers, gala, and year-end parties. I'll just point out a few issues on this specific slide. So fundraisers, at this point in time, given the COVID era, as we're calling it, there's a lot of fundraisers, unfortunately, that can't take place. So I know that a lot of associations and leagues and teams are trying to get creative to raise money. So please check with your association. Please check with Hockey Quebec before you go ahead and do any of these fundraisers, just to make sure that everything is covered with regards to risk management. And the same thing goes for year-end parties. It's, you know, it's funny to talk about year-end parties when we haven't really started the season yet, but year-end parties need to take place. You need to have a closure to your season. You just need to make sure that what is taking place at the year-end party is also covered under the insurance policy. So when we talk about sanctioned events, what is a sanctioned event? So sanction means any hockey event or activity that is recognized and or authorized by your region, by your local hockey association, and by Hockey Quebec. So it's important that when you are planning an event, if you're unsure if the event itself will be sanctioned, then that is when you get in touch with your hockey association and Hockey Quebec to get approval. So the three main insurance policies that are in place through Hockey Quebec are your general liability policy, your accidental death and dismemberment policy, and your directors and officers liability policy. The first two policies are through Hockey Canada, and the third policy, directors and officers, is actually done through the Regroupement Loisirs Québec, which oversees the sports and leisure associations within the province of Quebec. Your commercial general liability policy is a 3-year policy, which was just renewed on September 1st, 2020. Accidental death and dismemberment policy was also just renewed for a 3-year term. And your directors and officers liability policy is in force until April 1st, 2021. So what is covered? So the definition, let's go back here. The definition under the commercial general liability, this covers the legal liability imposed by a court for bodily injury or property damage claims in which negligence is determined. So again, this is for commercial general liability. I'll put the emphasis on bodily injury and property damage because those are the things that we obviously see the most in our office when a claim comes through. And I'll give you 3 examples. These are examples of, these aren't fictitious claims, these are actual claims that took place over the years. The first example is a player gets injured alleging that the ice was not maintained properly. A volunteer at a fundraiser causes damage to a rented facility, and a player accidentally gets injured in the dressing room alleging lack of supervision. So these are 3 examples. I can tell you we get on average 35 to 45 claims per year within the office. And so this is just a microscope of some of the claims that come through our office. Accidental death and dismemberment. So this is Hockey Canada's, what we call in our office, our catastrophic insurance policy. So it does cover accidental death and dismemberment, paralysis. So you have the 3 main paralysis: quadriplegia, paraplegia, and hemiplegia, as well as severe brain injury. Under the accidental death benefit, it's a $35,000 benefit. The paralysis and the severe brain injury is a $1.5 million benefit under the policy. Hockey Canada also has a self-insured program which covers medical and paramedical expenses as well as dental injury. The medical and paramedical expenses are in excess of parents' personal injuries and personal insurance, I should say, and that is in Canada only. Your directors and officers liability. So that policy, if you sit on a committee and you are part of the HCR, as I mentioned before, you would be part of the directors and officers liability policy. It is a $2 million limit. And as I mentioned, the policy is in force currently until April 1st, 2021. So this policy covers the provincial organization, leagues, regions, tournaments, minor hockey associations, and all of Hockey Canada, all of Hockey Quebec members. Directors and officers liability insurance covers the directors, the officers, employees, members, and volunteers for their exposure for the manner in which they conduct their affairs for their association. The policy covers defense costs, damages caused by wrongful acts, which are not excluded by the policy, and administrative errors and or omissions. Now, the impact of COVID on the sports insurance sector. Obviously, it has affected not only your sport, but all sports within Canada. But tonight, obviously, we are talking about hockey. Are we covered under our general liability in a COVID-19 situation? So Hockey Canada's insurance program, whom Hockey Quebec is a good member in standing, does not have a COVID-19 exclusion on their general liability policy. Now, some of you who are on this call may be part of other sports federations, sports associations. Your kids may be involved in other sports. Hockey is, by all accounts, one of the only sports within Canada that actually does not have an exclusion for COVID-19. And the simple reason for that is when we negotiated the renewal for Hockey Canada's insurance policy, that was done in February of 2020. So it is all about timing. It was good timing that we were able to do that prior to the pandemic. So the insurance company agreed, obviously, that they would not impose an exclusion on COVID-19 for the general liability policy, and that is for the 3 years that I just talked about before. So that is good until September 1st, 2023. Liability. Various organizations may be exposed to claims from third parties alleging negligence managing the virus outbreak, and that due to their negligence resulted in bodily injury or damages to third parties. Some insurance policies contain exclusion for claims arising from pandemic, virus, bacteria, which could preclude coverage for negligence claims arising out of COVID-19. So again, it's all about communication. We will talk a little bit about the risk management side of things, but it's all about keeping your members, your participants well informed as to what is going on during COVID-19. Phase 2, are we covered? So bodily injury definition under the policy reads, bodily injury means bodily injury, sickness, or disease sustained by a person, including death resulting from any of these at any time. Now, the courts have yet to take a position with regards to this specific coverage, as there hasn't been a claim yet. We are obviously in the early stages of COVID-19. So any claim that any of you who are on this call tonight may be aware of, if you do receive any verbal notice from any of your members, any written notice from any of your members with regards to any potential claim, and I'm talking whether it be COVID or any other potential claim against your association, your league, it's important that that gets relayed back to Hockey Quebec so that they can send that off to our office for review. If you have been following other provinces during the pandemic, the BC government actually issued a special ministerial order to protect amateur sports organizations. So in that province, nobody is allowed to take legal action for anything related to COVID. It is something that other provinces tried to do. Unfortunately, they have not been successful as of to date. So for your situation, your insurance policy, it is important that you realize that you do not have an exclusion under your policy for that. So are you covered under the directors and officers liability? Although directors and officers liability policies will generally exclude claims alleging direct bodily injury or property damage to a third party, such exclusions do not tend to exclude downstream or indirect claims that are based upon, in consequence of, or in a way related to bodily injury or property damage. The most important thing to remember as a board member is to respect and apply the required measures asked by the government and your local authorities. So again, it's all about the communication, keeping your members properly informed during this time. Our responsibility. So what are our responsibilities as far as members, as far as your role within your association, your league? So we need to follow the guidelines of your respective province, health, and safety authorities, adapt your risk and safety procedures to this new reality. You need, if you know, I'm sure all of you have this, you have a complete return to play or reopening plan that should be shared by your members and which are specific to COVID. As we've seen over the last few months, things change, and things change almost on a daily basis. So again, I'm going to reiterate the importance of keeping your members informed as to what's going on. Now is actually a time more than ever where you need to keep your members updated as to what is going on within your association and within the municipalities where your members do rent ice and do attend practices and games. If needed, make sure your plan is approved by competent authorities. Provide guidance, support, and training when needed to your members. Provide a COVID-19 questionnaire. So often before going into the arenas, I've seen that with my two girls when they're attending practice. Before you enter the rink, there's a member of the association who's checking to make sure that they don't have a fever. They ask 4 or 5 questions, and then they're allowed in. And that is something, as far as risk management goes, that all of you should be following whenever you have a practice, whenever you have dryland training, whenever you have hopefully games coming up. These are all things that need to be taken into account. Your assumption of risk form, which is something that Peter is going to be talking about, needs to be adapted to your activities. You need to make sure you are in constant communication with your membership. I think it's the 3rd or 4th time I mentioned that tonight, but it is really one of the most important things that you need to come away with from after this presentation is good communication with your membership. And make sure you communicate any changes or questions to your region. What's next? So the COVID-19 crisis is still very much prevalent, obviously. Hockey had started up at the beginning of September. We got about a month or so into hockey, and now we're back on what hopefully will be a short pause. But you need to understand all the changes that are going on within hockey, but also, as I mentioned before, within your municipalities. Many of the arenas right now will only allow one parent inside the rink when they drop off their children for practice. So it's really important that not only you keep up to date with what's happening in hockey, but you keep up to date what's happening at the facilities where your members will be practicing and playing. You need to keep monitoring the evolution of your provincial health and security authorities. You are a key player in prevention and risk management. So it is your role to pass along to your members with regards to risk management, with regards to safety issues. It's always best to side on the side of caution, as we say. You are the leaders in your region, and it's essential that we all work together to get through this global pandemic. On that note, I will pass the puck over to Peter Moratis, who will give you a brief presentation on the legal aspects of COVID.
Thank you, Mr. Lacoste. As you said, our second speaker, Mr. Peter Moratis, partner with the firm of Lapointe, Rosenstein, Marchand, Melançon, is a graduate of McGill University Faculty of Law Transsystemic Approach and holds a bachelor degrees in both common law and civil law. His practice encompasses all aspects of civil litigation and focuses mainly on insurance and both general and professional liability matters. Combining his passion for sports and law, he has developed extensive experience in sports law, particularly in the representation of sports federations and their administration. Outside of the office, Mr. Moratis is an avid athlete. In addition to having worked with the World Anti-Doping Agency during an internship, he holds a Hockey Canada Level 6 referee certification. Strongly involved in the legal and sporting communities, he sits on the Québec Bar's Professional Training Committee and the Montreal Bar Contest Committee, in addition to chairing Hockey Québec Provincial Officiating Committee and teaching civil procedure at the Québec Bar School. So, Peter, it's to you.
Thank you very much, Marie-Joëlle. I'd like to take the opportunity to thank Hockey Québec, its board of directors, and its management for the opportunity to speak with you here tonight. I would also like to thank all of you for being present. And thank you to Steve. I have the honor and pleasure of sharing the stage tonight with Steve Lacoste, who set the bar pretty high. I'm happy to see a couple of names that I recognize here tonight and that I got to meet in the context of my officiating duties with Hockey Québec. Like I said, Steve set the bar pretty high, so if I can get out of this with the least amount of booze possible, I'll consider it to be mission accomplished. So Steve gave us a pretty good overview of the insurance considerations with respect to COVID, namely with respect to the different types of insurance coverage that you'll find with respect to sports organizations, and in this case in particular, Hockey Québec and Hockey Canada's insurance programs. We're going to go over the legal considerations and the risk management considerations, both from a general perspective, and then we'll try to look at a couple of practical aspects in relation to COVID. So here's the overview of the agenda that I propose for tonight. So we'll begin by talking about civil liability in general. I think it's important to look at the general principles before we apply them to COVID more specifically. Then we'll look at the general principles involved in risk management, and then move towards a more practical approach with respect to risk mitigation techniques. And we'll finish off with a couple of considerations with respect to litigation, again, trying to tie it into COVID-19 more specifically. So civil liability. The first point that I'd like to make tonight is that civil liability under Quebec law, when we attempt to incur another person's civil liability, there is no particular regime that is imposed. So it's basically the general civil liability regime that will apply to situations in sport. And I've included a citation that has become quite popular in Quebec sports law from the matter of Zaccardo, which some of you may or may not be familiar with, but this is an instance where a court case did handle a situation where a player in hockey was injured, and it has become one of the leading cases in Quebec sports law. And so what the Judge Payette said in that particular case was, a hockey rink is not a lawless zone. The general rules of civil liability govern the events which unfold in the rink as they do any other human activity in Quebec. So it just goes to say that in Quebec, there is no specific or particular regime other than the basic civil liability regime that applies for any other situation in Quebec. So when we are looking at applying that regime of civil liability, a plaintiff must prove three things on a balance of probability. So we're not in a criminal matters where the burden of proof would be one of beyond a reasonable doubt. We're in a matter of civil liability here, which means probability, 51% chance that 51% chance of having to prove the following three elements. So the first is a fault, a civil fault or negligence on the part of the defendant. The second element that must be proved is injury or damage that results from the fault. And the third element that absolutely needs to be proven in order to incur the defendant's liability is a causal connection between the two. So just a practical example of those three elements being applied. If we go back to our case in Zaccardo, as I said, it was an instance in which a player in a midget AA game in 2010 was checked from behind by an opponent, pardon me, and as a result of the check, he sustained serious injury. He became paraplegic. So if we look at our three elements of civil liability and applied it to that particular scenario, because ultimately the outcome of the case was that the defendant, the player who did check him from behind, was found liable for the damage he caused to Zaccardo. So the first element, the fault. So what is the fault in that particular case? Well, it's the illegal action of checking a player from behind. What is the injury? Obviously, it's the injury that was sustained, the damage that was sustained by Zaccardo, being that he became paraplegic following the illegal act. And what is the causal connection between the two? Well, it's the fact that the injury, Zaccardo's paraplegia, was a direct consequence of the fault, which was the illegal check that he sustained. So that's just basically an example of the application of those three elements. And what's important to note is that no matter the characterization of the legal relationship between the parties, whether it be contractual or extra contractual, the three elements remain essentially the same. And just to explain, when I talk about contractual or extra contractual nature of the claim, in that particular case, going back to Zaccardo, between Zaccardo, one player from one team, and between his opponent who checked him from behind, the player of the other team, of the opposing team, there's no contract between the two players, right? I think everybody's capable of understanding that. So in that particular case, we'd be in an extra contractual situation. If we look, for instance, at a COVID situation where, for instance, one of your members was suing you as members of managers or directors of the association for not having put in place sufficient measures in order to ensure that the virus does not spread, and they were suing you on that basis, well, we'd probably be in a situation of contractual liability, in the sense that there's a contract between the association and its members, and that the members pay a membership fee in exchange for certain services, and implicit within that contract that is formed, there is an obligation of safety of your members. As an association, you must ensure the safety of your members, and we will speak about that a little bit later in this presentation. Before going to that particular notion, I'd like to show you the two, I would say, landmark codal provisions of the Civil Code of Quebec in relation to civil liability. It's Articles 1457 and 1458 of the Civil Code, and anyone who's done any type of study in law, whether it be in the context of accounting studies or even business studies, will have seen these articles. 1457 is the case, is the article that applies in the case of a extra contractual relationship, and 1458 is the article that applies in the context of a contractual relationship. But if we look at the provisions, you will see that in both cases, we're looking at a fault. So whether it be a civil fault under 1457 or a contractual fault under 1458, in both cases, we're looking for injury. And in both cases, there has to be that causal connection between the two. Once we've spoken about the elements in order to incur a defendant's liability, what's the defense? If I'm being sued, if you as managers or volunteers, directors of a sports association, whether it be at the local, regional, provincial, or national levels, the concepts are always the same. So the only defense that is recognized under civil, in the case of such civil liability, is the absence of fault. So your duty as a defendant, or your burden as a defendant, is to demonstrate that in the circumstances you have not committed a fault that engages your civil liability. And coming back to what I said earlier about the obligation of a sports organization, what's important to note is that an organization, as I said, does owe its participants and its members certain obligations. Namely, one of those is the safety of the participants, in order to ensure that as much as it is feasible, that it is attempting to prevent foreseeable accidents. But the good news here is that you are only held to an obligation of means, in that you must deploy the means, the reasonable means, in order to ensure the safety of your participants. And so what does that mean? It means you're expected to act diligently, and you're expected to act reasonably. You're not expected to act perfectly. And that's something that should be noted. Although it does not mean, and although that you do not have an obligation of result as opposed to an obligation of means, so you do not, the law does not impose upon you a burden of accomplishing a particular result. Nevertheless, you do have an obligation to act reasonably and diligently under the circumstances. And what a court will be looking at there is, how would a reasonable and diligent minor hockey association or regional hockey association have acted under the same circumstances? So that's the test. And already in 1991, the Quebec Court of Appeal recalled that principle, in the sense that, and for your information, a lot of these principles were developed, at least in Quebec sports law, were developed in ski cases, I guess because of the inherent danger with skiing, and probably because in most of those ski accidents, you are talking about serious injury. So they are matters that eventually did end up before the courts, and the courts did have that occasion to render judgments and specifying the different obligations of the parties. So in this particular case, the 1991 Court of Appeal case in L'Écuyer v. Quayle, which is a ski case, the court said the general obligation of surveillance and vigilance remains an obligation of means. It obliges the center, here it was a ski center, to take reasonable steps to protect its clients against foreseeable risk. It does not hold it responsible for the execution of an obligation of result. And so when we've explained the three elements that must be considered to incur someone's civil liability, and then we've spoken about what it is, what type of obligation we have as sports organizations, being an obligations of means to act diligently and reasonably under the circumstances. The next question that comes up is, well, how does one determine whether I was acting reasonably or not? And in sports in particular, we are subject to playing rules, to bylaws, to various regulations that come into play that govern our structure. And so that's probably a very good place to begin, and that's probably a place where the court will begin when it's analyzing whether or not, as a sports organization or as a director of a sports organization, I have acted diligently and I have acted reasonably in the circumstances. So it's not necessarily the case that because you did breach a particular rule or regulation that you have committed a civil fault, although the court may take that breach into analysis. So let's go with a couple of examples. So I'm sure all of you are well aware of Rule 2.5 of the Playing Rules of Hockey Canada, which provides that at any time while the play is in progress, you cannot have more than 6 players on the ice. And we all know that if you have more than 6 players on the ice while the play is in progress, you're liable to receive a 2-minute penalty. I think we can all agree that if you do transgress that particular rule, you are not incurring your civil liability, and it does not constitute a civil fault for which damages would be ultimately payable. On the other hand, there are other types of rules that can be characterized as expressing an elementary rule of caution. And I give an example of one that I believe is a pretty patent rule that is expressing an obligation of caution. And that's Rule 6.1, for instance, where we're talking about attempt to injure or deliberate injury in the case where a player or a team official deliberately attempts to injure or deliberately injures an opponent, in which case he will be assessed a match penalty. Those types of rules, of elementary rules of caution, are rules that the court not only can take into account, but must take into account when considering whether or not a particular action constitutes a civil fault. And in those particular cases, the violation of those types of rules may even constitute civil faults in and of themselves. So basically, to sum up those principles, how do we assess reasonable conduct of a party, or how will a court rather assess the reasonable conduct of a party? Well, we saw there's playing rules, there's administrative bylaws that Hockey Quebec and Hockey Canada put out, there are guidelines, there are policies, government regulations, and return to play protocols, in particular in this time of COVID, will be of utmost importance. We'll look at that a little bit later, but again, it comes down to the question of, the court will ask itself, how would a minor hockey association or a regional hockey association act under the circumstances? How would a reasonable organization act under the circumstances? And I would suggest, and we'll look at this, like I said, a little bit further, but I would suggest that a reasonable sports organization, whether it be at the local or regional level, would respect government regulations and would respect the return to play protocols that are in place. So those are just some things that the court can consider: standards, developments, trends, customs, the practices in that particular industry, and obviously the concepts that have been developed by case law will also influence a court's approach in assessing the reasonableness of the conduct of a defendant. I've entitled this slide Reality Check, and I think it's important that we all recognize that although most sports organizations, and hockey included, are volunteer-based or volunteer-led, that does not mean that the law cuts you any slack. You still have the same obligation of means to act, and I'm going to repeat this ad nauseum, to act reasonably and to act diligently in given circumstances. That said, the good news, as I have already stated, is that the law does not expect perfection, it expects reasonableness. Having gone over the general legal principles, and I attempted to give you a law course that generally spans over 3 or 4 years in the space of a couple of minutes here, let's talk now about risk management principles. So before delving into the principles themselves, let's talk about a couple of definitions. So everyone can agree that the risk, or when we're evaluating risk, is the chance of something happening that can have an impact on the achievement of the desired outcomes, on the achievement of our objectives. And risk management, in turn, is the process or the steps that we put into place in order to identify, to assess, and to treat risks so as to better achieve those desired outcomes and objectives that we have fixed for ourselves. And in risk management, the basic principles of risk management can be summed up in 3 different steps. The first step is the identification of the risks, of the potential risks. So it's basically asking ourselves, what can go wrong in a given situation? Once we've identified those risks, well, then the next step in the risk management process is to measure and to evaluate those risks. So it's asking ourselves, what is the chance that things will go wrong? And what are the potential consequences if they do? And finally, the last step in that risk management process is once we've identified and measured the potential risks, it's asking ourselves, what can we do about those risks that we have identified and measured in order to control them? And depending on how we've evaluated them, how we've measured them, well, it will be consequent on the control or the actions that we put in place in order to control them. So let's look at each of those components specifically and try to tie them to the current COVID situation. So with respect to identifying risks, I think that here is a pretty straightforward list of risks that are related to COVID. So you obviously have your compliance risks because as we did say, there are currently in place and they've been called to change almost every day in the past couple of months. The various government regulations that are in place, the return to play protocols that are set down by Hockey Canada and Hockey Québec, the provincial, municipal, territorial guidelines, those are all related to compliance. And obviously there is a risk when we are called as organizations to put them into place that we might not be respecting them, and that represents a certain risk. Then you have financial risk, and I don't think I have to delve very far into this issue. I think we all know that in various sectors, not only in the sports sector, but you think of all kinds of enterprises and businesses with the financial loss that they are currently facing because of closures. You all know that not too long ago, 2 days ago, all team sports were put on pause by the provincial government. So that will obviously, and especially in hockey, and you as minor hockey association or regional association directors are in a front row seat to know how this pandemic has caused financial damage to your associations, whether it be because of decreased membership or whether it be because, for instance, events that would normally bring back revenue to our associations, whether they be tournaments or any other type of fundraising events, cannot take place. So the financial risks are definitely present. Communications risk, and that's something that we in the past have challenged and even criticized our governments for, sometimes the confusion that they have spread out through their communications. And obviously, Steve touched on this point, and I'm going to touch upon it further. One of the major ways that we are going to control the risks in this particular situation is communication with our members. And obviously, when we are putting out that communication, there's always a risk that it can be confusing, that it's not clear, and that can have potential consequences. obviously the operational risks. If we are deciding to operate under current COVID circumstances, there are operational risks to that, whether it be your members, your participants, your actual committee members getting sick, the consequences of that, all kinds of different operational risks that we can think of in terms of the various steps that we'd want to put into place and what kind of consequences they can have on the operation of our activities. They're definitely present. And finally, reputational risks. We don't want to be the Minor Hockey Association where there are, you know, not too long, just today, the Blainville Armada of the Q, 18 of their players were tested positive for COVID. I mean, that has a certain effect on their reputation. You do not want to be singled out as the association where there was that outbreak of COVID, and that association that was identified for not having taken the appropriate measures in order to mitigate the spread of the virus. So those are general, and I mean, the list goes on, but I think those are some of the major risks that we can talk about in relation to COVID-19 in particular. That's the first step, identifying the risks. Once we've identified the risks, as we said earlier, the next step is actually measuring or evaluating those risks. And it's basically evaluated on a scale from low to catastrophic. So without going into too much detail, each of those risks that we identified, well, we'll be able to categorize them as being either low, which means that they would have an impact on the achievement of our results, but that they can generally be dealt with through simple internal adjustments. Moving to medium, you're talking there about risks that would have an impact or some impact on the achievement of our results, but that we, in order to mitigate them, they would require actual changes, whether it be to strategy or to the actual delivery of our programs. High would be risks that significantly impact the achievement of our results. And then catastrophic, we'd be talking about risks that would have a debilitating impact on the achievement of our results. Once we've evaluated the risk, the last step in our risk management process is then controlling the risks. And essentially, this is very theoretical, but again, let's try and we're going to move it and take it to a more practical approach when we talk specifically about COVID and the techniques for mitigating the risks. But from a theoretical approach, there are 4 ways of controlling risks. The first is retaining the risk. So we spoke about it earlier, or we're actually going to speak about it more in depth when we talk about waivers and assumption of risk. But the first way of controlling risks is by retaining it, which means that you don't need to do anything in particular because the risk that you are evaluating or attempting to control is one that is inherent to the sport. So let's look at a practical example of that. In hockey, for instance, we all know that ice is slippery. And we all know that when we go out on the ice with a skate on and a metal blade in contact with a slippy surface such as ice, there is a risk that we might fall. And in most instances, we won't necessarily decide to do very much about it, besides maybe impose the wearing of certain equipment, which is already provided for by the rules. But there isn't necessarily a specific particular measure that has to be put into place because the risk of falling on a slippy surface when practicing hockey is inherent to the sport. Reduction of risks. So this is the one probably that will be most pertinent with respect to COVID because this is the means of controlling a risk in which we will take actual steps, we will put in place actual procedures, actual measures in order to reduce the likelihood of that risk actually manifesting itself. And how do we do that? We do that by changing human behavior. And how do we change human behavior? Well, we do that mainly by imposing rules. And we'll look at that a little bit later. Transfer of risks. You're basically accepting the level of risk, but you're transferring the control or the risk itself to a third party through contracts. So you'll see that namely with respect to with subcontracting. So for instance, if you're subcontracting your evaluation process, or you're subcontracting certain coaching sessions to a third party who has its own insurance contracts, its own procedures that are in place, and you're basically transferring the risk onto that third entity in order to perform the work in your stead. And the most common method for transferring risk is insurance policies. That's why we underwrite them. It's in order to transfer the risk to our insurance company. And in the event that the risk does manifest itself, well, we know that there's an insurer that's there to defend us and to potentially indemnify the party that is pursuing us in the context of legal proceedings. The last means of controlling the risk is avoiding the risk, which means basically not operating or not allowing a participant to take place in your activity if they are not respecting the guidelines which you have put into place. So for instance, if you've put in certain measures in place and somebody, one of your members would like to participate in a particular event without respecting those particular measures, well, you could decide that you will not allow them to take place or to take part in your activities, in which case you'd be simply avoiding the risk because you are not allowing the activity to take place. We've spoken about the theoretical approach to risk mitigation. Now let's talk about the actual techniques that we can put into place, and particularly with respect to COVID. So Steve touched upon this point, and I'm going to reiterate it here. It is absolutely crucial that you adhere to all provincial and territorial government regulations, guidelines, policies, as well as the return to play protocols. Hockey Quebec has elaborated a very, I would say, well-written and complete return to play protocol. And like I said earlier, when a court is looking to assess whether or not a sports organization was reasonable or not in its conduct, it will be looking at this type of thing. And as I said, I think that a court would easily come to the conclusion that a reasonable sports organization would have respected those provincial government regulations, the guidelines, as well as the return to play protocol. So they are of utmost importance in a risk analysis and ultimate civil liability analysis. You also know that all organizations and businesses should develop and implement policies and procedures in order to mitigate the transmission of COVID when they are reopening their sport, or whether it be the actual organization of activities, or whether it is the opening even of their offices. In all spheres, this is the case. And there are precautionary measures to be taken. And what do those precautionary measures include? I said it earlier, I'm going to say it again: communication, communication, communication. The more you are in a position to communicate the measures that you did put in place, the less your members will be able to say that they were not informed, because we will see later on that under the assumption of risks theory and the analysis that the court has to take into account under that chapter, you must demonstrate that your member was fully aware of the risks. So how are we going to do that? We're going to do that through communication. There are other methods. We're going to talk about the whole issue of the waiver, but communication, communication, communication is key. Then there are procedures and systems, namely for regular cleaning, sanitization, inspection of equipment. And what's really important when talking about that is the records that must be kept when we are taking those steps. So it's a little bit like when we go to any public restroom, there is that form that we can see oftentimes on the door, where we can see that such and such employee cleaned the bathroom at this time on this date. Well, it's the same principle here. And why is that important? in the context of potential litigation, it's because as a defendant, you have to prove, as we said earlier and as I've repeated, that you have acted reasonably. In order to prove that you have acted reasonably, obviously you will be able to count on the testimony maybe of certain people, but it is also really important, and I think it would be an even safer bet to have those records where you can show by documentary evidence that equipment was inspected, it was sanitized, it was cleaned, and that those procedures were not only procedures that were put on paper, they were actually put into practice. Then there's the posting of clear signs in your rinks, the declarations and attestations of health. I think everyone is well aware of that, and I think that in general, minors hockey associations in the past couple of weeks have done a good job in ensuring that their players, before going out on the ice, whether it be to practice or to play, are all signing and filling out those attestations and declarations of health. I heard on Monday night we gave this conference in French, and my co-host Sacha Vaillancourt was telling us that in his minor hockey association, they actually had an app where they can just show up at the rink, scan a barcode, complete the health attestation, and if it wasn't completed, they weren't allowed in. So that's really important. I think it's part of that, standard of being reasonable and diligent. It's making sure that before you let them out on the ice, that they have attested to the fact that they don't have any symptoms, all those general questions that we're asked wherever we go. And then the last element that has to be looked at from a practical approach, and for which we hear a lot about, but we don't necessarily know how it applies, especially in Quebec, is the whole concept of assumption of risk. And I specifically say assumption of risk and not waiver, even though I did say waiver earlier, because in Quebec, especially in the case, and I'm tying this back to COVID, but of bodily injury, we cannot waive our rights and we cannot waive the actual risk for bodily injury. And that's why it's important under Quebec law to talk of assumption of risk rather than actual waiver when we are talking about bodily injury. But let's look at that a little bit more closely. Before talking about actual assumption of risk, I just wanted to touch upon, once again, Hockey Quebec's protocol. You've all seen, I'm sure, this diagram with the 6 steps. We are currently in phase 5, or we were in phase 5 before this temporary pause that the government imposed. But what's really important, and again, I cannot stress this enough, is that most likely a court, in assessing whether or not someone has been reasonable, especially in Quebec, with respect to hockey, well, the first thing a court is going to look at is, well, what are the procedures, what are the protocol that the sports federation, the provincial sports federation, has put in place? And we're lucky in that Hockey Quebec has provided a pretty voluminous and well garnished document that provides for a lot of the situations and gives us a lot of tools in order to ensure the safety of our members. So it is absolutely crucial as a first step of ensuring that you are acting reasonably to respect those guidelines and those protocols that are put in place. Let's talk now more closely about assumption of risks. And this is really important because we do hear all kinds of things, whether we watch movies or we see on TV how it may apply, and we hear about waivers, and we sign waivers in a bunch of activities that we participate in, whether it be, parachuting or any other activity that can be dangerous in and of itself. Whenever we sign up, we're asked to sign a waiver. What's important to note, and this is different with respect to other common law provinces. You all know that in Quebec, we're governed by the civil law. And in Quebec, we cannot exclude or limit our liability for bodily injury. It's important because we can exclude it for material injury, as long as you can see at Article 1474 of the Civil Code, as long as we're not excluding intentional or gross fault. But with respect to bodily injury or moral injury, we cannot exclude or limit our liability. and that's what it says at 1474, he may not in any way exclude or limit his liability for bodily or moral injury caused to another. So what does that mean? In the context of sport, although we cannot exclude our liability, for bodily injury, a person who does participate in a sporting activity, in principle, does assume and accept the risks related to the practice of the sport. And this comes back to what I said earlier. What's important to note is that the person does not accept just any and all risks. He only accepts the risks that are inherent to the activity and of which he or she is aware. So that comes back to 2 points we touched on earlier, that we're looking at risks that are inherent, and not only must they be inherent, but we have to make them aware of those risks ahead of time. So when we talk about inherent risks and relate that more specifically to COVID, although, like Steve said, there is no particular ruling that has been rendered by the courts with respect to liability, at least to my knowledge, in the context of COVID, in the sense that I have not seen any decisions, whether it be in Quebec or elsewhere in Canada, where someone was suing a defendant because of his negligence or because of a fault he committed in allowing the plaintiff to contract COVID. I have not seen any cases to that effect. Although the courts have not decided any cases on that particular issue, I think it's safe to say, under the circumstances, that in the context of a pandemic, where everyone knows how contagious this particular disease is, I think that the court would come to the conclusion that the fact of participating in a sport where you're surrounded by other people, that there is a risk, and that risk is inherent to the fact that you are participating in a sport surrounded by other people in the context of a pandemic. So I would venture out to say that the risk of contracting COVID when playing a team sport in particular is probably an inherent risk to the activity. So I think on that aspect we'd be covered, but the question is then, how are we making our participants aware? And the second element that's really important under Quebec civil law, and that departs a little bit from common law provinces, is that it is not because a victim assumes or accepts the risk that he or she waives his or her right to a recourse or his remedy against the author or the perpetrator of the harm, which means that it's not because the person accepted the risk that they waive their right to sue the party that caused the injury. What they do not give up, in fact, is any aggravation of the risk. So, to put that a little bit more simply, if, again, back in the case of COVID, if you as a minor hockey association are sued because you acted negligently, if the person accepted the risk of contracting COVID before actually participating in the activity, but that you as a minor hockey association committed a fault or were negligent in putting the measures in place, well, you will still be held liable for the aggravation of the risk that resulted from that fault that you committed. So it is not like in other common law provinces where we can simply say ahead of time, well, you're giving up, you're accepting any and all bodily injury that can occur when you step foot onto the ice, and you sign that off. And not only that, you're going to waive any right you have to sue us if that particular risk does come to fruition. Well, in Quebec, unfortunately, those types of waivers are completely null, in the sense that they will not preclude a party from their recourse. However, where it becomes important, and that's what we're going to look at now, is when the party that is signing such an assumption of risk form is recognizing or accepting or assuming a risk that is inherent. And that's why in this particular case, and that we are obviously reasonable and act diligently as sports organizations. So That is why in this particular case, where COVID-19 or the risk of contracting COVID-19 is probably an inherent risk to the activity, that's why it's important that, one, we act diligently and we act reasonably in putting those measures into place. And secondly, that we do have assumption of risk forms that are signed, because those risks are inherent, and that we will be able to use them as proof that the person was made aware of those risks, because those are the two elements that must be proven, as I just stated earlier. So let's, just before looking at a practical example of that assumption of risk form, because Hockey Quebec has provided one, and I do want to look at that just quickly with all of you. But before that, I'd like to cite what I thought was an elegant formulation of the rule of assumption of risk that we can find in this particular decision. And what the court said was the maxim of Valenti, which is the notion of assumption of risk, should not be applied with the same rigor as may be the case under the common law. Under our law, which is Quebec civil law, the mere knowledge of a danger by the victim is not sufficient to exonerate the third party from a fault, except where the knowledge of the risk is such that we can deduce a free and conscious acceptance of the danger to which the victim is exposed. And that is the standard that we must meet. So what's important here is that we have to, the knowledge of the victim has to be such that we can deduce a clear, conscious acceptance of the danger. So let's look at a practical example, and this is taken from Hockey Quebec's Code of Ethics for Administrators. And within that Code of Ethics, which everyone will be required to sign, if they haven't already done so, there is an acknowledgement or an assumption with respect to the risks relating to COVID-19. So we see in that particular passage that we say to completely fulfill his mandate, an administrator must, and then we see that he must commit to comply with all requirements and recommendations of the Quebec Public Health and other government authorities, and to put in place and adopt all necessary measures to do so in respect with the Federation's return to hockey plan. So as you can see, when we were talking about, well, what are the obligations that a minor hockey association or a regional association have, well, you're imposing certain obligations on yourselves. So this is the type of thing the court will look at it. When I was talking about how crucial it is to respect those guidelines, it's all the more crucial because you yourselves are imposing that obligation on yourselves to respect and to comply with all of those guidelines and recommendations that are put in place. So it's all the more important to do so. And then further on, you will find in that same acknowledgement form that we are talking about the coronavirus as being declared a worldwide pandemic. We're talking about the fact that it is spread mainly by contact from person to person, and that we have to put in those measures and processes in order to reduce the spread of the virus. More concretely, and this is where I would say the actual crux of the assumption of risks forms resides, is where we say that by signing this document, I acknowledge certain things. And when we were talking about, the criteria in order to have a valid assumption of risk, there were two. One, that the risk is inherent, and two, that the person is made aware of the risk. And we'll see this general knowledge of a risk under Quebec civil law is not sufficient. As we saw in that passage from the decision in Doucet, the degree of knowledge has to be such that the person essentially, we can deduce that the person consciously and clearly accepted the danger and obviously the consequences of that danger. So let's look at and see if that's the case in this particular assumption of risk form. So first we start off by saying that by signing this document, I acknowledge the highly contagious nature of COVID-19 and I voluntarily assume the risk that I or my child, if my child is a minor, could be exposed or infected by COVID-19 by participating in Hockey Quebec or Minor Hockey Association activities. And so there we have the fact that if I do participate, there is a risk that I will contract the disease. And then, to be even clearer, and I think this is also important, we give an overview of what the consequences may be, where we say being exposed or infected by COVID-19 may particularly lead to injuries, diseases, or other illnesses. So I think right there, we have the elements that are needed in order to ensure that when someone signs this form, well, and they were to contract COVID nevertheless, and they were to decide to sue, whether it be a regional or minor hockey association, well, I think this will be a valid and probative element that will be put into evidence in your defense in order to demonstrate that that particular person not only was aware, fully aware of the risks, but formally acknowledged them, and not only the risks, but also the consequences, the potential consequences of those risks. So that's quite important. I think that these types of forms will be particularly useful in COVID-19 cases, and I would suggest and recommend that all administrators, all members, all parents sign this type of form. Before going any further and touching on certain points that I wanted to touch on with respect to litigation, I do want to touch very briefly on the issue of incorporation and what we call the corporate veil. Luckily in Quebec, most, if not all, minor hockey associations and regional associations are incorporated. So they are incorporated into legal persons under namely Part 3 of the Quebec Companies Act. What that does, obviously, is it's a method of limiting your liability because it is not your personal patrimony as an administrator that is that can be called into play if ever you are sued. It's the actual organizations or legal persons' patrimony that is in play because legal persons are recognized, they have their own juridical personality, and they may exercise their rights, which means that they can, in their own name, so your associations, when they are incorporated, they can, under their own name, sign contracts, purchase property, be sued, and incur their own liability. And that protects, obviously, the individual members from having to pay any of the liabilities or debts of the organization because they are incorporated. Obviously, there are also further means that can protect, whether it be organizations or their administrators, and Steve touched upon those. We're talking about your commercial general liability policy or your directors and officers liability policy. To conclude, I'd like to talk about a couple of matters in relation to litigation, specifically with respect to COVID. So as a general rule, and obviously it's not always the case, but in bodily injury cases, so if we were to take the example of someone contracting COVID and suing a minor hockey association or regional association, as the case may be, their lawyer will generally work on a contingency fee basis, which means that their lawyer's fees will be paid as a function of the amount ultimately awarded. So to take a very simple example, if you are being sued for $100,000 for damages caused by your fault in relation to someone contracting COVID, for instance, well, if ultimately the person did succeed and was awarded that $100,000 in terms of damages, well, $30,000 or $40,000, because that's generally the range, 30 to 40%, would go to their lawyer for compensation for their legal fees. The reason why I'm talking about this is because, as Steve said, we're lucky in the timing, in the sense that the Hockey Canada insurance policy was underwritten in February, right before the pandemic began. So Hockey Canada's insurer did not include any type of exclusion with relation to COVID. But I can tell you from experience, and I gave the same type of conference not too long ago to another sports, national sports federation, whose insurance policy did comprise a COVID-19 exclusion. And I would say also from experience that in most industries, most insurers have included endorsements in which they are excluding formally COVID-19 or any other transmissible disease for that matter. So we are lucky in the sense that, at least for the time being, there are no exclusions with respect to COVID specifically, but that's not the case for most businesses and for most sports organizations who have recently renewed their policies. So what's important to know is that the reason why personal injury lawyers will generally work on a contingency fee basis, and in so doing will most of the time artificially exaggerate the amount claimed, because ultimately it means more for them at the end of the day if they succeed, is because at the end of the day, most organizations or businesses, whatever the case may be, that they do decide to sue are defended by insurance companies, which means that there are deep pockets at the end of all this, if ever they are to succeed, whether it be before a court or whether it be in the context of a settlement. Where the portrait changes is in the case where there is no insurance. And like I said, luckily we do not seem to have that problem in hockey, but in other sports, there is no insurance that will cover cases of COVID. So in the same instance where a person who has contracted COVID will be suing a sports organization, they will have to defend themselves. And if the lawyer knows that there is no more coverage because of an exclusion, well, first of all, the lawyer will probably want to charge an hourly rate to his client who is claiming those amounts, because there's a potential chance that he will not be able to recover anything. And for one, that will make the process a lot more expensive. But for two, it might also incite those plaintiffs to exercise their recourses against regional, provincial, or national sports federations, because generally those bodies will typically have deeper pockets if, in fact, they are not insured for COVID. So why am I saying this is because no matter what level you are at and whether or not there is insurance, what's important is that, again, I'm coming back to this and I'm going to conclude on this, is that whole, what I've been reiterating from the beginning of this presentation is that as a sports organization, no matter what level you are at, you must act reasonably and diligently. And that's how the best defense you will ever have against any type of recourse in this particular case. And the Zaccardo case, which I mentioned at the outset, is a good example of that, because in that particular case, at the outset, Zaccardo had decided to sue his opponent who checked him from behind, but also Hockey Quebec and Hockey Canada. And shortly before the trial, Zaccardo's attorneys actually discontinued their proceedings, which basically means they abandoned their proceedings against Hockey Quebec and Hockey Canada, because they realized that they would never have succeeded on their claim, because their claim was that Hockey Quebec and Hockey Canada had not taken sufficient or reasonable means to prevent checking from behind. And the way that Hockey Quebec and Hockey Canada got out of it was by demonstrating with the various materials that were produced, with the guidelines, with the standards of play, with the rules that were put into place, the emphases that were put on those rules. They were able to show that they had taken the reasonable and diligent means to prevent checking from behind. And that's why the suit was dropped against them. And finally, Zaccardo just continued to trial against his opponent, leaving Hockey Quebec and Hockey Canada out of it. So that would be a pretty good example of what could occur if ever this was to come to fruition with respect to COVID. I'm going to end by saying that even though there is a risk that you might be sued if you do not take into account and put into place the appropriate measures, I think that when we talked about the three elements that have to be proven in terms of civil liability, the third element, the causation element, the causal link between the fault and the damage, I think that there is going to be a little bit of the plaintiff is going to have a hard time to prove that the actual method of transmission of COVID-19, whether or not he can relate that directly or connect that directly to the measures that you have or have not put into place. But that does not mean that we shouldn't be diligent and that we shouldn't act reasonably in order to put those measures into place. We mustn't forget that the burden of proof always rests with the plaintiff because he is alleging the fault, so therefore he has to prove it on a balance of probability. And luckily, in most cases, damages may be minimal or even inexistent because, again, luckily, the vast majority of people who have contracted COVID, the consequences or the damages, if we would call them as such, are basically the same symptoms as a seasonal flu. In those cases, which is the vast majority of cases, I highly doubt that those can be qualified as actual damages that can be compensable in terms of civil liability. Now, there will be cases where somebody gets really sick, is hospitalized over longer periods of time, can even have permanent consequences from having contracted the disease, or in other cases may even die. In those cases, arguably, there would be damages that could be claimed. But again, I think we'll have the same issue with respect to causation. And if you do a good job in putting into place those measures and procedures, always acting reasonably and diligently as would a reasonable sports organization, I think that we'll be in a pretty good position if ever that kind of case does present itself. So on that note, I'd like to thank you very much for your attention, for being here tonight for this conference. And you have my contact information on the screen. If ever you do have any questions, please feel free. And I know that Hockey Quebec will be putting out also a Q&A document answering certain questions as well. So thank you very much for your participation and attention here tonight. Thank you.
Thank you, Peter. As you said, in a few days, we will send you the link of the recording of this event with the Q&A, so you will be able to share it with your members. I will leave the last word to our General Manager, Mr. Paul Menard.
Thank you, Marie-Joelle. Thank you, everybody, to attend these conferences tonight. In these uncertain times, we are looking for answers, and there was quite a few tonight, and you will receive, like Marie-Joelle has mentioned, the recording and the Q&A also from the other conferences at the same time. Just before I say thank you to Steve and Peter, there's one thing that Steve did mention, and as well Peter later on in his presentation, is to follow the return to play plan and follow this protocol to go back to hockey. It is important. We have a plan that has been accepted not only by public health, but also recommended by the ministry to other federations. And we have a plan that really could help you out in managing the return to play. So thank you, Steve, for your presentation. Thank you, Peter. Marie-Joelle, thank you for your there was a challenge. Marie-Joelle had a challenge. She said, I'll take it. So good for you. So here we go. Yvan, thank you very much. Yves, thank you very much being there for us all the time. So the only thing I could say to you is we're going through a little bit of time now. There's a pause for some of you not. So let's get ready. So when we do go back, well, our kids will go back into a safe environment, and let's do things right. And for those of you that are keeping going, just make sure that everything is in place, like Peter and Steve has mentioned. And let's stick to the plan, and let's operate in due diligence, as was mentioned a lot. So thank you very much, and have a good evening.